I'm Nikki Jovicic from LookUpStrata and also the Managing Director of Tower Body Corporate. We're joined by Todd Garsden from Mahoneys and Will Marquand from Tower Body Corporate. Todd and Will are talking about the ins and outs of body corporate contracts. This is a Queensland session and the information refers specifically to Queensland legislation. The complexity of body corporate management contracts regularly leads to confusion and disagreement over services and fees. Today, Todd and Will are breaking down the standard clauses in the management agreement, covering agreed and professional services, what level of indemnity the manager carries, how you can end the relationship with your manager if things aren't going well, plus much more. Why are management contracts structured the way they are? Todd and Will give us a behind the scenes look at the reasons, and they present you with hints and tips on what to look for when reviewing your next agreement. Before we begin, I'd like to mention that the information contained in today's session, including the discussions that arise from submitted questions and chat conversations, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in the session. So we're joined by Todd Garsden from Mahoneys and Will Marquand from Tower Body Corporate today. Todd is an experienced property lawyer who specialises in body corporate law. Todd predominantly acts for body corporate managers and lot owners on all matters affecting bodies corporate. He has a focus on achieving practical and commercial results for his clients. He's an active member of SCA Queensland, and in 2019 he was appointed to the SCA Legislation Committee and assists in making submissions on behalf of the SCA on issues such as legislative reform in body corporate law. Todd is also a body corporate committee member himself, so he understands the day-to-day requirements of administering a body corporate. And Will joined the Tower Body Corporate team as a general manager and senior strata manager in 2020. As a licensed strata manager, Will has widespread experience across all forms of commercial, industrial and residential schemes. And Will is a former journalist and teacher, and he believes in proactive, ethical strata management and is passionate about providing Tower's customers with knowledge and support to take their schemes forward into the next generation of body corporate management. So both Todd and Will regularly join us for webinars. You've probably seen them in one of our webinars before, and they contribute to content on the LookUpStrata site. Both are frequently asked to apply their knowledgeable and practical minds to help our Queensland audience with their tricky body corporate questions. So once again, we welcome Todd and Will, and thanks for joining us.
Good morning. Hello, everybody out there.
Thanks, Nikki.
Excellent, thank you.
So, Todd, we wanted to have this discussion today because our basic thesis is that a lot of people don't really understand how body corporate managers' contracts work. That can include body corporate managers themselves sometimes on occasion. And we have to look at why people don't understand them. They're fairly long, complex documents. And they have lots of different clauses in that people may struggle to read and relate to their ordinary lives and the ordinary interactions with the body corporate managers that they deal with. So the idea behind today's session is to give you some insight into how the contracts actually work and what you can expect to see if you're reviewing your individual contract. What I want to say at the beginning is all of the discussion that we're going to have coming up is very generic in nature. If you want to know about your contract, you should check your contract with your body corporate manager. So don't just assume that what we're saying here automatically applies to your contract. It's a contract, so you have to look at what you have rather than what we're necessarily presenting on the screen. When I'm going out and about talking to owners about what contracts are and how they work, I make a big point of trying to explain to them how a contract actually is broken down and what its constituent parts are. What a lot of people are not always aware of is the contract is really in two parts, which is agreed services and professional services. And the agreed services, I often explain to people, are generally the services covered by the base management fees. An easy shorthand way of thinking about them is that they're the services that you need as a body corporate to keep your scheme legal throughout the year. And then in addition to that, you have a range of professional services, and these are costs for any kind of service that you can ask the body corporate manager to perform at any stage through the management contract, which aren't covered under an agreed service, which they will charge additional costs for. Todd, do you agree with that?
Yeah, and I mean, that's, I think, probably the most important part of what you want to be looking for in the contract, so that you know what you're actually agreeing to get, and you know what is going to cost you extra. So, I mean, um, as you said, every body corporate management contract is going to be different. There's a lot of templates out there that some organisations provide, but in its most fundamental terms, there are three key elements, and that's how long does it go for, what are you doing for the agreement, and that's what Will's just spoke about there, and how much is it going to cost. And a lot of the time, there's a disconnect between what people think they're getting and what they're actually going to be paying for. So I think if you want to understand three parts of it, they're the three things you really want to understand. Obviously, you normally got a 7 to 10 page document that's got a whole bunch of other clauses in there. Some of them are going to be more relevant than others, but they're all there for a purpose. So that's, I guess, what we're trying to do today is get a better understanding in some more basic terms of what those key clauses that you want to look out for really are.
One of the first questions I often get asked is why aren't body corporate contracts all inclusive? Why don't we just list one price, this is it, and that covers all of the work that we do throughout the year?
Yeah, and I mean, the simple answer is no two individuals and no two body corporate is going to be the same. The work you put in with one building that may have 100 lots might be significantly less than the work you put into for a heavily disputed 6-lot building down the road. It doesn't particularly make sense to be charging them a flat rate when you're putting 80% of your time into one building and the other building sort of floats along. So it shouldn't necessarily be subsidizing one over the other. So there's obviously some core services that are needed for every single body corporate. That's to keep the show running. That's to meet all the compliance requirements of the module and the Act and all the 500 sections. And to me, that's what 9 times out of 10 is going to make up the agreed services, your AGMs, your minutes, making sure everything sort of runs along. The professional services, or sometimes they're called additional services, is what you pay extra for. They're the things that sort of people can add value. Some committees want to have a hands-off approach, and that's great. That'll save them some money, but some want the employed manager or the engaged manager to do all that extra work for them, and that's also okay. So it's really structured to allow for a little bit of flexibility between the nature of the scheme and how the committee want to operate their scheme.
So it's really a user pays type contract, isn't it? It's the more you use the services of the managers, the more you pay, and the less you use the services of the managers, well, in theory, the lower that your cost should be.
Yeah, and I think it's a little bit unfair sometimes on managers, because I think the general misunderstanding, not necessarily from committee members as much, but particularly from owners, is that the additional services or the professional services are what they're already paying for. And that's just not the case. An owner doesn't have an agreement with the body corporate manager. It's the body corporate. The body corporate is the client, not the owner. So owners tend to think that their levies get paid to the body corporate manager to do anything they want related to the body corporate. And it puts the manager in a tough spot, because they have to manage someone who's related to the client, but not necessarily the client. And ultimately that bill goes to the body corporate. So a lot of the time there's a bit of a slippery slope of good body corporate managers trying to help out their client and doing a lot of professional services without actually fairly charging for that additional service.
Yeah, that can be quite commonly the case, where the manager's being asked to do a lot of work and then they're not always confident or sure of exactly how much they should be charged or should be charging on that basis. I think it's a topic that we'll come to later with one of the questions. Okay, so the contract's broken up into 2 areas. Agreed services, I'm calling them professional services. Some people call them additional services. In your contract, they might be listed as Schedule B, C, and D, or something along those lines. You have to check your own individual contract to see what they are. But personally, I prefer the nomenclature professional services. That might be because I'm a body corporate manager, and that's what I feel that we deliver. Other people might see them just as additional services because they view them as additional costs. Whatever the wording that you want to use, that's okay with me. What we're looking at here is the agreed services. So these are the services that are provided as part of the fixed fees within the contract. And it's usually broken up into 2 areas, which is sort of secretarial services and financial services. And this is here, we can see a list of some of the typical secretarial services that are on offer. Todd, have you got any comments on this? This is not a definitive list necessarily. And again, check your contract to see exactly what's included in your contract. But this is a fairly standard list of what might be included.
Yeah, and this is what I was alluding to before about these are the core things that need to happen for every single body corporate to keep things ticking along. It's effectively the bare minimum to operate. So that's what this list really tries to put together.
Okay. On the list here, I can see sort of if we look at like the 5th item down, it says prepare and distribute notices for committee meetings. And then it's got like a number 4 in brackets. What, you know, why do we have little numbers notations like this?
Yeah. And that's kind of what we're talking about before, Will, because every body corporate's different. You can have a committee that has a budget committee meeting once a year before the AGM, and that's really all the hand-holding they need. There are other ones that want to have a committee meeting every month or even more frequently. So that cost of operating or managing that body corporate on the body corporate manager is going to vary significantly between one meeting a year or potentially 10, 12, 15 meetings a year. So 4 is probably, you know, a bit of an industry standard. You know, once a quarter we'll deal with the issues. To sort of cap it on that basis is really to protect the body corporate manager from a committee who wants unlimited meetings all of the time every month. You can just imagine the internal cost on the manager to do that is never going to be captured or recovered in the agreed fee.
So I would say to all owners out there, if you're checking your contract, check how many meetings are included. It could be anything from, well, you know, 4 is a common number for a larger building, but it could just be 1 meeting, or it could be 0 for a smaller building as well. What you need to bear in mind from a manager's perspective is that having meetings costs money. It takes a lot of time for the manager to prepare and attend the meeting, and it takes quite a lot of time for the manager to put together the minutes. And so the costs of that have to be factored into your contract. So the more meetings you have, the more the base fees will have to consider the inclusion of those meetings.
Yeah, and if you look at your contract and say it's allowing for 6 and you only need 2 or 3, then perhaps next time it's up for renewal, chat to the manager about, hey, we probably don't need to have so many fees, so many meetings included in the fees. Why don't we reduce that? And then if we need more, we'll pay extra for it.
Yeah, I think it's a real area where I think if you want to negotiate your contracts, that's probably a key point when you can negotiate and maybe cut back or maybe increase as you need to. So the last one looked at the agreed services, which was the secretarial services. And then also within the agreed services, you're likely to get a range of financial services. We've listed a typical range of them here. It's things like opening or operating your bank account, paying your, sending out your levy notices, and paying accounts. It's fairly standard accounting. I don't think there's too much to say here, Todd. I don't know if you've got any particular points.
No, not really. And I think the next slide will be able to answer some of the questions that have been put through as well.
So that's what you get for your, you know, when you look at your base contract and when you say you maybe pay $150 for managerial fees and $50 for disbursements, that's the agreed services, and that's what's covered under your fixed costs. And after that, well, we'll move on to the next slide. We have professional services. So this is the area where things tend to get a little bit more controversial, where there tend to be more disputes between body corporates and body corporate managers. And it tends to be the area of the biggest misunderstanding, where people don't really understand what the difference between their basic costs are and then all of the additional costs that can add up over the year. As a general rule, the body corporate manager can charge for kind of any kind of legal request by the body corporate that isn't covered under as an agreed service, wouldn't you say, Todd?
That's exactly right. And I think this is where the grey or the misunderstanding really is. Because a lot of the time, the body corporate manager won't charge anywhere near what they're entitled to charge under the agreement. And I can see a lot of the questions coming through are asking, well, it's not clear what they would be charging when we go and ask them questions or seek advice. And whatever's in that professional services or additional services section or schedule of the agreement is what they're entitled. Now, sometimes that's an hourly rate. If it's a particular task you're asking them to do, there might be a pre-agreed fee for that. But ultimately, if you're sending the body corporate manager a number of questions, and those questions are on some sort of novel issue that don't relate to the normal routine minutes or financial operation of the scheme, they're entitled to put the clock on and charge for that, because they're not being paid to do it. They're doing it as an additional service, and they're entitled to be remunerated for that additional service. And by the looks of the comments coming through, this is probably the main theme, and it's not surprising because of this being the general misunderstanding in the industry. And I think it's perpetuated because a lot of body corporate managers probably don't charge what they're entitled to, which creates this expectation that, well, we email them and we don't get charged, so we can keep doing it.
Do you find that body corporate managers are comfortable talking about their contract, or is it something that they feel a bit awkward about?
It's not necessarily, it's not something they're comfortable with, and I think for a number of reasons. It's in some of the bigger firms, they're not the ones that deal with the contract. It's part of a back of house process. They don't have necessarily flexibility to change the contract. That they're not really the party to the contract. They're working for the party to the contract. So there's a bit of a misunderstanding, a misapprehension, a concern about how it would legally be interpreted, which is a little bit unfortunate because they're really at the coalface of those questions and those issues.
Yeah, I've definitely found a lot of the managers I've dealt with feel pretty uneasy if you ask them any questions about the contract. It's not that they don't know what it is, but it's somehow that they feel if the customer's asking them a question, they feel that the question's kind of negative, and they feel very defensive in having to justify what's actually just an agreed something that's already been agreed within the contract. So they feel the manager themselves often doesn't want to have that conversation, and then so they try to sort of elide it if they possibly can. I think that's kind of problematic for the industry, because what you have then is no one really asks the question, and it's only after the fact when the customer gets the bill and maybe is a little bit annoyed about it that the issues come up. Whereas in fact, what should probably be happening, and what I'd encourage all owners out there to be doing, is when you're at a point of maybe engaging a new manager or having a contract renewal with your current manager, take that time to say to them, well, can you explain your contract to us? Can you explain how does it work, or what kind of costs you might be expecting to charge us over the next 12 months or something like that? And so that you're creating an opportunity for them to maybe feel a little bit more comfortable and to present some of the ideas in the contract to you so that you can have a better understanding of it. And then, well, if the manager does really feel uncomfortable about it, or if they can't give you clear answers, maybe that's a problem, and you need to have a think about what to do next. But ideally, they should be happy to answer your points and explain clearly the items that are in the contract for you. It's a conversation, I think, that doesn't happen nearly enough. I try to trigger it myself at some points when I'm having discussions with customers, but generally I've found that not enough people have actually asked me specific questions about the contract. They've just sort of looked at, they say, what are your costs? They say, well, they look at the base fees, and they say, okay, that's the cost, and that's what we're making our decision on. And very few people actually read the contracts and try to understand it and try to understand all of its implications. And that's where a lot of the problems start from.
Yeah, and I think that answers John Hutchison's question there about, what sort of level of disclosure of the additional services or professional services should be made. And it's, yeah, all disclosure. You're entitled to know what you're being charged for. If you're being charged for it, you should know what it is. So I don't think that should really be too much of an argument.
Yeah. There's just a question I can see up there from Jason Griffiths. He said, should you be advising the client when there is a cost, i.e. a breach of bylaw letter, so that there's no surprise at them when they see that there's a fee at the end? So really what he's kind of saying is every time the body corporate manager is applying a fee, should there be a conversation with the customer to say, okay, I'm doing this work and there's going to be an associated fee for it?
I mean, it's a client expectation and client management type question. There should be that discussion beforehand, but keeping in mind that the contract has already effectively given the legal basis to charge that and carry out that work. They're being asked to do something. The contract they've already got says they're entitled to charge for it, but it's more of a client management process of making sure that they're aware of it. Shouldn't necessarily need to happen every time, but it's a prudent way of going about it.
Yeah, I mean, personally, I tend to think that the conversation should happen at the renewal stage, and then you should be when you're talking about establishing the contract. That's the time really to have the discussion. If you're in a situation where every single time the client's asking you to do something and you're saying, okay, well, that's going to cost $40 or $80 or whatever it might be, it just changes the nature of the type of conversation that you're having, and the focus for the client comes more on then how much it's costing rather than resolving the actual issue at hand. So I think it would be quite awkward for managers to constantly be saying, okay, I'm doing this for you. This is an additional professional service that's going to cost X. But then, as you say, they also should bear in mind that there's probably times when they just need to remind people that that's happening, that they say, okay, you've asked me to do this. Please bear in mind it's going to take me 3 or 4 hours of office time. You might not need to list all of the costs, but I think it does behoove managers to provide just nudges to people just to say, yeah, bear in mind, you're asking for this now, but it's going to take quite a bit of time, and you can expect to see all of that cost on your balance sheet at the end of the year. So within the professional services, then, what are the areas that cause services to rise, do you think, Todd? What leads to substantial services being added up?
Yeah, it's really when there's unanticipated issues. If there's a big improvement project going on and it goes sort of haywire, and the body corporate manager needs to now dedicate their day to resolving the issue for the committee, that can add up quite fast and quite costly. But ultimately, if the body corporate manager wasn't there managing the actual process of it, it's probably not going to go anywhere. It happens a lot when there's a particular let's say nuisance owner involved in the scheme that is constantly communicating on to the body corporate through the body corporate manager, and there are a number of obligations that arise when that happens in terms of record keeping and seeking instructions from committee, considering submitted motions, getting directions from the committee. As you said before, every minute body corporate manager spends, it's costing them money, and the agreement entitles them to recover the cost of doing that. Ultimately, if they weren't doing it, it would fall on individual committee members to do it, and I'm pretty sure they're not going to want to do that out of their own personal time. So it's really when those out of the blue unanticipated issues take place, and they're really not things that should be in the agreed service. It's just going to make it impossible for the body corporate manager to operate.
Yeah. I tend to find there's kind of two big areas where the costs can go up quite quickly. Anytime you're involving the body corporate manager in maintenance issues, that tends to be an additional service cost. So the body corporate manager is not your building manager. That's not the work that's included in their contract. So if you're coming to them regularly to resolve building maintenance issues, that's fine. I think they're happy to do that, and they're often very well placed to assist you with that. But the more hours that they spend doing that, the costs tend to go up quite quickly. The other area where I find that costs rise very quickly is when there's disputes, particularly among committee members, or when you have owners who are unable to follow the bylaws. Managers spend hours and hours and hours trying to negotiate between committee members when people can't agree amongst each other, or when people are unhappy to negotiate or talk with each other. The manager's often placed in the middle of that conversation. It's very hard, but it's a very difficult spot for the managers to be in, because they're trying to be fair to all parties. They're trying to provide all people with reasonable advice, and it takes an awful lot of time to do that. And that tends to be a significant cost of, I would say, mostly unnecessary professional services from the point of view of the body corporates. They could be resolving things by just, talking amongst themselves, or being prepared to negotiate or compromise a little bit more amongst themselves. But when people are unwilling to compromise, or when they can't follow clear directions or clear bylaw or something like that, the issue just goes on and on and on and on and on, and then as a result, the costs kind of pile up very quickly. So I think owners out there should really be looking at those two areas, you know, maintenance and disputes, and think about how much time it takes the body corporate manager to do them, and whether they could be relieving some of that pressure themselves, or maybe they say they're happy for the body corporate manager to keep doing that work, but you should be conscious of it. So when it comes to the contracts, a lot of people want to know how you might end a contract with a body corporate manager. You know, when you want to end a contract with a body corporate manager, there's a variety of different ways, but most managerial contracts will have a clause in it relating to termination. I've put up sort of standard clause here. Todd, would you like to sort of take us through the steps that you might go through if you want to end your contract with a manager?
Yeah, and it's similar sort of discussion in terms of management rights, and that's because it's a similar type of arrangement. It's a contract between a body corporate and a service contractor, and once that takes place, it's regulated by the Act, and that's why point 1 is there. And the reality is there's a process to go through to terminate the agreement, and that's commonly known as, you know, remedial action notice is probably the one that's most commonly referred to in relation to the Act. There's a few other technical ones, but ultimately the manager needs to be breaching the contract. You need to give them an opportunity to remedy the breach, and if they don't, there is a process to actually bring that contract to an end. Something that can't be understated and is commonly missed is the fact that you've entered into a contract. Just because you don't like it anymore doesn't mean you can just walk away from it. You know, the manager's contract will normally between 1 and 3 years. It's, I guess, in terms of body corporate, not a particularly long time, but to wait something out 2.5 years if you're not happy after 6 months can take some time. So unless the manager is actually breaching the agreement, there's very little that can be done to bring it to an end unless you want to pay them what they're entitled to under the rest of the contract. So the termination provisions need to be, I think, looked through the lens of, well, we've agreed to do this for 3 years. So not necessarily we're locked in for that period, but the expectation is it's going to go to the end of the term unless something goes very skew with, and there are rights there if that happens.
A lot of people just end their contract when it comes to, or the end of the contract. Like it often falls in line with the AGM. The natural end, the contract's ended, say, on 30th of August. The AGM's on 30th of August. When you have that situation, do the body corporates need to have a motion on the agenda to officially end the contract, or is it sufficient just to sort of let it run out?
As soon as the term runs out, it's brought to an end. So there's no formal process to terminate or confirm that it's been brought to an end. It will expire. Once it expires, that they're not under contract, the only way to get a new contract is to go to a general meeting and pass an ordinary resolution. There is a way where you can sort of temporarily have a body corporate manager help you in the interim period, as sort of a consultancy role, but they're not acting and cannot act as your body corporate manager until they've been approved at general meeting. So timing the end dates with your actual AGM can be quite difficult sometimes, and that sometimes necessitates an EGM to align things or balance things up. But yes, I think there's a few comments coming through sort of indicating, you know, these terms seem very favoured in terms of the body corporate manager. I don't necessarily agree that's the case. The manager incurs a cost in taking client on, setting the body corporate up. They probably don't actually make money until at least a year into the agreement, when they've actually understood what the requirements of the building are. So they once they're under contract, they need to be protected under that contract to continue. And there are ultimately rights to bring that to an end if they're not performing. But if the manager's performing, they should be entitled to see the end of their contract out. And that's a pretty fundamental basis for any contract, that you can't just get out of it when you want to. That's the reverse of why a contract exists.
A lot of people see an inequity between, you know, within the clause here, we can see that the manager is allowed to cancel the contract with, say, 30 days. Some contracts might say 60 days or 90 days, but they've mostly got a clause of this nature in them. And then the body corporate can't really cancel its contract. Well, it can cancel the contract with the manager, but if it does, it's usually required to pay out the rest of the contract. A lot of people see that as iniquitous. it's, you know, the balance isn't there. Do you agree with that?
Yeah, and I mean that's kind of what we've sort of just been chatting about. The manager could be signing on to a manager body corporate, which is just completely impossible for them to efficiently manage. And I don't think a manager would ever be taking on a client that they're going to be locked into if it's going to negatively affect their business. No one should want a body corporate manager to be losing money on any client they pick up, because it's ultimately detrimental to the body corporate they're managing, the rest of their clients, potentially the industry. So if a manager has picked up a client and they no longer want them as a client, it's a different nature of the relationship to the body corporate being managed by that manager. So they are not the same rights between the body corporate and the body corporate manager, but there are real reasons for that to take place.
Yeah, and that's what I tell people. Like, as someone who runs a business, when we take on a body corporate scheme, we are incurring various fixed costs. We have to have an office, we have to have a legal structure around the company, we have to provide a manager. That manager has to have a computer, that manager has to have enough time to service the client. There's a range of costs that we're incurring when we're making that promise to manage a scheme. And it's very difficult for us to just change those costs around at, say, 30 days notice all the time. So if you had a situation where all of the management companies maybe had a 30-day termination clause within their contract, and I know that some companies do have those clauses included, the net result would probably be that we'd have to factor in that fluctuation into our costs, and body corporates would just end up paying the higher costs as we to cover the fluctuation, I think.
Yep.
Yeah. Okay.
Yeah.
And then in this, one of the other questions that often comes up is that the managerial term can be up to 3 years. Some people prefer 1-year contracts, some prefer 3. Is there a particular advantage to signing a 3-year contract?
I mean, it's a set and forget type question. You don't have to worry about it for 3 years. You can sometimes get some sort of better economies of scale with the agreed fees, because the body corporate manager knows that, well, I don't need to compete for this work for another 2 years, so I'm going to help them out over that period. There's a little bit of a risk management type thing. So it's really horses for courses. If it's a new manager and you're not quite sure about how they're going to operate, or if it's a good fit, then perhaps a shorter term would work better, so that you can reassess in that 12 months. But if you do that, I think you should be prepared to understand that it's probably going to cost you more in the short term, because there's a bit of a risk management strategy for both parties. But if you're comfortable with how they're going to operate, they're going to do a good job, you want to get a little bit of a favourable discount, then 3 years or 2 years or somewhere in between can sometimes be more appropriate.
Yeah, I think the main advantage is to lock in costs, isn't it? For a longer contract, a lot of management agencies might provide a little bit of a discount on their base costs, because they know that they're going to get the fees coming in for a longer period of time. And then the fees get controlled across the period of the contract, so that, well, at the moment we're having a situation where probably the costs of body corporate management are going up quite quickly. So if you're signing a 12-month contract each time, then the contract you sign today might be a little bit different in 12 months' time, and in 24 months' time it might be higher still. Whereas if you sign a 3-year contract today, you can at least have that certainty that the prices will be fixed across that period. So I think it's up to each individual body corporate to sort of consider that and weigh up the pros and cons. If we could move to the last slide, I think this is an important one that I often get asked about, which is that people ask about what the indemnity levels of the body corporate manager are. And a lot of people feel that they're not high enough. Todd, I wonder if you could just comment on this one.
Yeah, and I suppose of all the clauses and terms we're sort of talking about today, this is probably the most technically legal type one to chat about. And I mean, it's important for a couple of reasons, and I think you'll find a clause like what's on the screen now in almost any professional services contract. So there's 2 parts to it, as you can see in 1 and 2. One's a release and one's an indemnification. So the release is obviously saying from the body corporate to the manager that they're not going to effectively sue the manager if they've done something wrong. Now, that might on its face sound quite rudimentary or unfair, But it comes back to what we've been discussing the last 10 minutes, where it's about a risk management type thing. If the manager was going to take on a client and expose themselves to a whole heap of liability in doing so, either they can't charge what they are intending to charge, and to compensate them for that risk to operate the business, the fees would have to go up tenfold. So it's some level of protection for the manager to operate the business with some comfort, and some sort of efficiencies without worrying that they're going to be sued for any little mistake done by the body corporate. Now, the key part to what's in most clauses is what's that last little sentence, which excludes things where the body corporate manager was negligent. So if they have done something wrong, and it's very wrong and it's negligent, then obviously they shouldn't be protected from what they've done wrong. So it is a one-sided clause, I suppose, but it's a balanced clause. It's kind of, I guess, what's been industry accepted in not just this industry, but across the board in service contracts. And similarly, the indemnity has a similar purpose. It sort of protects the manager if they're going to get sued because of something they're connected with the body corporate that the body corporate does wrong, so that the manager can rely on the body corporate to sort of guarantee or reimburse them if they've been caught up in something the body corporate's done wrong. So they are.
What could be classified as negligence by a body corporate manager? I mean, from my end, we're not, the managers aren't really in control of the sites according to the contracts. It's the committees that are in control of the sites. So what's negligence? Once we're aware of an issue, we make the committee aware of it. Is that where we stop? Is that the end of our liability as managers?
Not necessarily. So it's obviously very circumstantial dependent. But I mean, one way you could think about it is if there was some type of legal claim put on the body corporate. The body corporate committee instructed the manager to call a general meeting to get direction from the owners or get authority to spend money to solve the issue or address the issue or take building defect action. The manager sat on it. The manager ignored it. The manager didn't act in accordance with those instructions. They were lazy. They dropped the ball. They didn't call the meeting that needed to take place to allow the body corporate to protect themselves or potentially recover some money from a builder for building defects. And all of a sudden, the timeframes expired, and the body corporate's lost that opportunity and has now suffered loss. It's probably negligent in that circumstance that the body corporate manager didn't act on the instructions of the committee, dropped the ball, didn't take some sort of proactive action when they were told to, and because of that, the body corporate has missed out. So that's probably the best example there is that the body corporate manager has been told to do something they should have done. They didn't do it, and it's sort of put the body corporate in a worse position.
Okay, that's fair enough. I mean, when I'm talking to customers and they say, well, why do you have such limited liability? I often say to them, look, I'd be prepared to take on more liability, but I'd want to have more control over what's happening at your site. If you're prepared to give me that, if I can control, your expenditure, if I can take the authority over how you manage safety things or something like that, then fine, you're welcome to give that to me. And I will take on the liability, but I'll also have to take on the control as well. And then, that's not really how the system's set up to work. And I think that's why the liability is limited, because we only have so much, when I say we as body corporate managers, they only have so much power to influence what happens at the site. At the end of the day, they're kind of advisors rather than actors or directors of what happens at the scheme.
That's probably a really good way of explaining it, because you're not a decision maker. You're a non-voting committee member specifically. You're there in a secretarial and treasurer capacity, just sort of the administrative side. So yeah, I think that's a really good point.
Okay, good. All right, that's the end of our slides. I think there was a question up here that we received from Ross, and he was talking about how a lot of body corporate contracts have a clause in them that says that if the body corporate manager doesn't arrange the insurance for the scheme, the body corporate manager is entitled to claim back from the scheme any potential commission that they might have received as a result of not doing the work. It's quite a controversial clause. I don't know what your opinions are on that one.
Yeah, very, very controversial clause. A lot of discussion about that type of arrangement has been had over the last couple of years, particularly with the recent reforms to the modules that require the dollar amount of commissions to be disclosed. And I know there's a lot of other disclosure questions that have come through. On one side of the argument, on the body corporate side and Ross's side, it does seem extraordinary that a manager can charge a body corporate a fee for effectively missing out on an opportunity of an insurance commission. The other side of the coin is, in very rough, broad terms, sometimes insurance commissions are up to a third of the revenue of managing a contract. And that's important because we want our body corporate managers to be able to make a fair profit. So if you're cutting a third of their revenue out, they've got to make that up somewhere else. And that's only going to come back to the agreed fixed fee services, because they're probably undercutting on those, knowing that they're going to make some money back from an insurer. So it's really, is the insurer going to pay and subsidize the performance of the manager, or are they going to have to increase the fees to make it commercial to operate? So it's a very loaded question, I suppose, and there's no right or wrong answer. You can sort of see it from both sides.
Yeah, I think that any body corporate that is activating that clause, they're probably doing so knowing that the relationship with the body corporate they're representing is going to end fairly soon. Because I can't imagine that any body corporate would be happy with the body corporate manager using that clause. Basically, what they would see it as, taking money without doing any work.
Yeah, it's kind of a disincentive to use insurance other than through the body corporate manager. So it's almost like effectively works as an exclusivity clause, which you can't really have to force them to get insurance through the body corporate manager.
Our body corporate manager recently charged the body corporate for additional services to conduct an EGM. When asked to provide a breakdown of those charges to determine the accuracy and reasonableness of the costs, our request was declined. Our solicitor provides an itemised list which clearly accounts for their professional services charged. Is our body corporate manager under any obligation to do the same? It's my opinion many committees may be failing their fiduciary duties to owners by simply accepting and paying charges. On reviewing our disbursements, I found our scheme had been charged for several emails and other costs relating to other schemes.
Yeah, I guess that does sound like a bit of an issue. Lawyers have a different regime of rules they operate under. We have to give that disclosure when requested within a particular time frame. So body corporate managers don't have those same rules, but depending on the contract, they might have to give a particular level of explanation or disclosure of what those charges are. And if they can't justify them or actually show that they incurred them, then they're not entitled to charge for it. They've charged them for something that the contract doesn't allow them to do so. So there might not be a regulatory requirement to do it, but there is a requirement through most likely the contract. And if they haven't done it, then the body corporate's able to sort of recover those amounts. So, I mean, on one hand, it's good that you're checking those fees. I suspect a lot of people don't. On the other hand, if you want to make sure they're being properly charged for what they're being properly serviced by.
Yeah, there isn't a set format, is there? But I always sort of use the standard of, I think body corporate managers should provide invoices that they themselves would be happy to approve if they were coming from any other contractor. So we get invoices from plumbers, electricians, a whole range of different people. And sometimes we send them back. We say, what is this? You haven't listed what the costs are. You haven't said how long you were there. You haven't said any of the work that you've done. You just put a number down and no one knows what you've done. We're not going to pay it. Or, we'd recommend that the body corporate shouldn't pay this one. If you can't meet that standard yourself within your own invoicing, then customers have every right, I think, to come back and ask the questions about, you haven't about how much time it's taken and how much effort has been put into doing it, rather than just a sort of a back of the envelope calculation without any justification of the work. So for me, I think that's the standard. Would you accept that? Would you accept this invoice from any other contractor? And if the answer is yes, then maybe it's fine. And if the answer is no, well then that should probably be resolved at some point. But
Yeah, and if it's something that the committee is particularly concerned about, then when the next management contract comes up for discussion, then you should put a clause in that requires them to do it.
Yeah, absolutely. I mean, what I will say is for customers out there, you're always welcome to go back and check the invoices, or you should be welcome to. You know, when it comes time to the end of the quarter or the end of the year, when you're checking all of the costs for the body corporate, ask the managers to supply all of the invoices that's been charged and have a look through them. They should be happy to do it. It shouldn't be very hard for them to provide that information either. You can also ask for the invoices to be approved, sent through and approved, just as they are for any other contractor as well. So as managers, we don't necessarily just have to put through our own costs and rubber stamp them. We can put them through to you as customers, and then you have the right to approve them as you see fit, just as you would approve an electrician's costs or a plumber's costs. So if you have particular concerns, that might be an area that you want to discuss with your manager.
Okay, and this second question is similar, and it's very similar to what we've just discussed then, but I'm a secretary of a medium to large body corporate covering about 72 houses and villas. A new strata manager agreed by email prior to appointment that their fees would be a set amount covering all costs except audit and BAS preparation. We now find that they have charged 2 additional monthly fees covering insurance bills to villa owners and gardening costs. Both items appear on the levy invoices issued every 4 months. With our financial year end now closed, they've refused to reverse these additional charges, totaling almost $1,500, even though we have pointed out the error and provided the original email as evidence. They refuse to give us access to StrataMax to print account details for our income and expenditure. So we're relying on them to email us a copy at the beginning of each month. And previously, the committee had full access to the account details via StrataMax. The strata manager says we don't need access, and they do not give this to any of their clients. Without this detail, we would never have known the hidden additional fees were being billed.
It's an interesting question. I think it's probably a little bit more behind the scenes to it, because if the body corporate manager is charging owners for insurance and gardening costs, I don't think they're the costs of the manager. They would, the body corporate is obliged to recover the cost of an insurance through the levy, and I suspect the manager is just doing that in accordance with what they're obliged to do under the Act and in the agreement. Those costs, don't think they're being paid to the manager. I think the manager is just operating them. But the second part of the question, I think, is a little bit different, where, I mean, they're entitled to see what those costs relate to and see records in StrataMax. So I think that's probably a bit of a separate issue about whether or not they're entitled to see those documents. So I'd say they're entitled to see the documents, but I don't think it's really going to change too much. Will, would you agree?
I just think anytime a manager's kind of restricting access to documents or refusing access to documents, it's a bit of a red flag, and they're causing problems for themselves in providing that kind of advice. If the customer's asking for it, it's just they're just asking for their information. So as the manager, you should be reasonably happy and comfortable to provide it. Whatever sort of software system you use in the background, most of the time this information can be produced. Click of a couple of buttons and you can send it off with an email or two. So it seems odd to me that the manager wouldn't want to clarify their position. As you say, Todd, the manager's position might be totally justifiable. The costs that are in question here may be just perfectly normal, legitimate costs. But if you're the manager, why wouldn't you want to say that? It just strikes me as a little bit odd that doesn't happen. And I think anytime you've got a manager telling you things like you don't need that information, or other people aren't asking for that information, or something along those lines, for me, that's a warning sign. That's a warning sign that there's something not. I'm not saying it's something inappropriate happening, but just why would the manager say that? Why would you say that as opposed to, okay, here's your information, I can present it to you fairly easily. In this case, they were talking about limiting access to StrataMax. I mean, for anyone who doesn't know, StrataMax is a major sort of software provider to the body corporate industry. There's a few other similar ones. They generally provide, back end software support to body corporate managers, and then sort of front end access to portals and things like that for body corporate customers. Most of the time with those portals, you can access them without having reference to the body corporate manager. And most of the time, information about your scheme some information about your scheme at least should be available via the portal. So I think you could probably independently log into Strata Max and access that information yourself without the manager having to authorize it in some way. And on that site, you should at very least be able to see your balance sheet and get a clear financial position of where things stand. And again, that's the type of information that I think good managers want their customers to have an access. Ideally, I want my customers to be accessing it because I don't want them coming to me to ask, to ask for information that's like readily available to them in another place. If that information isn't available, I think it's, why not? You really need to ask that question as to why it's not available, because it's so easy to provide these days.
So possibly it's more of a transparency issue, and if they were able to see their records that they should have access to, it would become clear what those charges were anyway.
Yeah, well, quite possibly, but why wouldn't the manager be transparent?
Okay, there was a second part to that question saying it's further complicated by the 2-year management agreement never being signed by either party. Is there anything we can do, or do we have to wait until the end of the agreement later this year and insist on a clearer and more precise agreement rather than go to war now?
Yeah, it's probably a bit of missing information. Was the agreement properly approved at the general meeting, and the committee just hasn't given effect to signing it as they are obliged to do if the motion has passed? I think it's more a question of, has that motion passed? Was it properly considered at the general meeting? Is the terms of the agreement consistent with the motion? Does it meet all the requirements of the module? So there's a number of questions, I guess, to respond to that question. But I mean, if it's only got 6-ish months left, it might not be worth taking up the fight.
Do the contracts have to be signed to become legal, or is the agreement at the motion of the approval at the meeting, is that sufficient?
No, it needs to be signed, but there's an obligation once the motion's passed to sign the agreement. So if it became an issue, if the body corporate was suggesting, hey, you can't enforce this agreement against us because we never signed it, it's a pretty easy argument to turn around and say, well, that's well and good, but you've got an obligation to sign it, and you can't use your failure to comply with an obligation to get yourself out of something. So it should be signed, but it doesn't necessarily mean it's fatal that it hasn't been.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.